All right, Bismillah Rahman Rahim. Assalamu alaikum, everyone. Thank you for joining us tonight for our webinar. My name is Nadeem Mian. I'm the portfolio manager for SHariaPortfolio Canada. With us today, we have a guest speaker, Brother Ibrahim Danial. And the topic for the webinar today is wills. Protect your family, preserve your property, and inshallah, we're going to get to hear Brother Ibrahim talk about that. And, his presentation will be followed up with hopefully a healthy Q&A. But before I introduce Brother Ibrahim, here's just a quick disclaimer, standard procedure as far as SHariaPortfolio and our liabilities and what we are not liable for. So just a little bit about SHariaPortfolio. For those of you who are either new to the firm, never heard of us, SHariaPortfolio, next slide here. So SHariaPortfolio, we offer professionally managed investment solutions that help Muslims basically achieve their financial goals while making sure that it's in line with their Islamic faith. We are currently licensed in Ontario, British Columbia, and Alberta, the Alberta Securities Commission. So that's the OSC, BC, SC, and the ASC. And we are registered as a portfolio manager in Canada. We are also the only dedicated Sharia compliant portfolio manager in Canada. So this is basically what we specialize in, and the only thing that we do is, like I said, helping Canadian Muslims achieve their financial goals while making sure that it's in line with their faith. The parent company, SHariaPortfolio, is based in the U.S. and it was founded in 2003. And the firm there has been registered with the U.S. Securities and Exchange Commission. So, alhamdulillah, we've been servicing the American Muslim population there for 17 years as a registered advisor firm. Currently, right now, with the Canadian operation, we are now we have clients in Canada. Of course, in the U.S., our parent company takes care of our American clientele. And here also from our Toronto office, we do cater to international clients as well. We do everything, all types of accounts. So non-registered cash accounts, RSPs, TFSAs. So really it's the full gambit in terms of the types of service and products that we offer. There are right now two levels of service. One is the express service, which we like to call a great, economical solution for the new investor, for anybody who's looking to kind of get started, and you're looking to kind of, put your money, just get started, whether it's for your child's education or just in general. The express is a low account management fee solution that we offer that strictly deals with our ETF portfolios. Then, of course, we have the access service. That is a service, that I would say is more customized towards, more experienced investors, individuals that have, I guess you could say, more assets to invest and are looking for more of an actively managed portfolio. So those are the two offerings we have. We have, in Canada, we are partnered up with Fidelity Investments. They serve as our custodian bank. So every client that does open an account with us at SHariaPortfolio, their accounts are actually held with Fidelity Investments, which is one of the largest global institutions in the world. They manage close to $3 trillion under management. So the account is held there, the online access, everything, all those custodial services are provided by Fidelity Investments. Fidelity is a member of the CIPF. And that simply means that's called the Canadian Investment Protection Fund, which is kind of like the CDIC that we have for banks. In the event that if Fidelity were to kind of go insolvent, every account is insured up to $1 million. So that's a little bit about us. Of course, we're here today to hear Brother Ibrahim. Just some quick words on Brother Ibrahim Danial. He's a principal at Danial Law. He practices exclusively in the area of wills and powers of attorney. Ibrahim previously worked at two Canada's leading law firms on Bay Street in Toronto, and he also holds a computer science degree from the University of Alberta and a law degree from the University of Toronto. His practice includes a focus on Islamic wills, in particular, how to maintain equitable dispositions in a non-traditional society. He is also the founder and director of a community of over 2,000 professionals in the Greater Toronto area. And without further ado, Brother Ibrahim, welcome. Assalamu alaikum.
Assalamu alaikum, Nadeem. Thank you. Thanks so much for inviting me, and thanks to you and the team at SHariaPortfolio. It's my pleasure to join you and your audience today. So before I start the presentation, I just want to also give my disclaimers as lawyers and finance people do. So nothing today will be specific legal advice. It'll be general legal advice. And also I practice in Ontario, so the laws that I'm talking about are Ontario specific. Generally in Canada, outside of Quebec, most of the provinces have similar laws, but there are important differences. As Nadeem kindly mentioned, the focus, inshallah, will be on how do we reconcile the ongoing tension between, trying to stay true to our tradition, but also in a, postmodern society where everything's changed and not a lot of scholarly analysis has gone into how do we reconcile these differences. So for the last 10, 12 years, alhamdulillah, I've been working with scholars, formally and informally, to figure out how we can try to manage these conflicting, sometimes complementary issues. So Bismillah ar-Rahman ar-Rahim. I'll just hopefully start my presentation.
And also to all the attendees, please feel free to type in your questions in the Q&A. There's a Q&A tab at the bottom. If you just kind of glaze your mouse to the bottom, you can see that there's a Q&A tab. You can input your questions there. And at the end of the presentation, inshallah, I will go through the questions and we'll present them to the brother.
Thank you, Nadeem. You can see my presentation?
Yes.
Okay, perfect. Okay, so I'm going to start because I think most of us are thinking of all these issues from an Islamic perspective. So there's a few hadiths about the importance of having a will, and there's a couple of variants, but it's actually quite, it always shocks me that 1400 years ago, Rasulullah sallallahu alaihi wasallam said to have a written will and not to be without it for more than 2 nights. There's some variations, 2 or 3 nights, but it's quite amazing. And I'm not a litigation lawyer, but lots of money's made by people fighting over estates. And by having this, and we'll talk about the Islamic mixed distribution, how a lot of conflicts can be reduced, subhanAllah. So I'm going to begin by just making sure we're all on the same page. Now, I'm not going to read all the slides because we have a lot of information to get through. So I'll just give you some of the highlights. But basically, as you probably know, a will is a declaration, a legal declaration or legal document saying how you will pass your assets on after you pass away. And you can do other things in a will. You can appoint, and this is one of the most important reasons to have a will. If you have minor children, you can appoint guardians for your minor children in the will. You can also set up trusts, different types of trusts. In a will, it's called a testamentary trust. And these are generally to protect your beneficiary or to execute your wishes in a certain way. So what a trust is basically, as you may know, there are 2 ways to give a gift, or there's 2 ways to pass an asset. Either absolutely, so the person you give the asset to gets it and has absolute or full control of the asset. This is after you passed away. The second way is you pass it in a way that they may not control it, or they may not control it right away, but they will be the beneficiary of it. So you can also, what we do in all wills is we name an executor. So executor is also called the estate trustee. And it's exactly that, a trustee who manages the assets in the estate and gives it out to the beneficiaries. Now, the executor is often the major beneficiary. For example, if people name their spouse, as we normally do, as the executor, the spouse may also, or is likely also, a beneficiary. And in Islamic law is one of the mandatory beneficiaries. There's certain things that we want to do in a will, if possible. So one of the things in Ontario and most jurisdictions, there's something called a probate tax, which is a wealth transfer tax. We'll get more into it later. But it's basically what we do in a will is try to, if possible, defer or reduce those taxes. We'll get into that more, as I mentioned. We also may need to protect the assets of disabled beneficiaries, the assets that you want to pass to disabled beneficiaries, because they may lose their benefits if they don't receive them. And I'll talk about it in the next slide, more clear, hopefully. If we do not have a will, we can face increased administrative costs, delays in passing the beneficiaries, because the court will have to approve for an executor rather than the ones named in the will. In the worst case, if we don't have family members, the state could inherit all our assets. That's rare, but it does happen from time to time. And for Muslims, we may not, of course, be doing the Islamic distribution or portions of the Islamic distribution that we might want to do or that we are trying to do. So we'll begin with guardians. So how should we pick guardians? So obviously we should pick people that we think are suitable for managing our children physically. So in terms of values and worldview. Now, how this is technically done is we name them in the will, they become interim guardians, and then they apply to become permanent guardians. And because we don't obviously will or bequeath our children, everything is in the best interest of the child according to the legal standard. But generally, or almost always, the court will approve of the guardians selected by the parents. The court doesn't want to be guessing that. As I mentioned earlier, trust, one of the major things, so basically all wills, people who have minor beneficiaries, we name guardians, so minor meaning under the age of 18 in most jurisdictions. And we also want to protect young adult beneficiaries. So say you have a teenage son who's 19, you don't want to give him $1 million, even though he's legally allowed to control it by Ontario law. Like if he's just named in the will as a beneficiary and he's 19 years old when, God forbid, you passed away, and both parents passed away, say, you don't necessarily want to give $1 million to a 19-year-old boy, even if he's a legal adult. So we do phased distributions in the will, and that's, as I mentioned, a testamentary trust. Usually, as rule of thumb, we give a certain portion at age 21, 23, and then the balance at 25. For very large estates, if you have many millions of dollars, we may extend that to a later age. But the majority of wills, we do 21 to 25 for phased distribution. Now, generally speaking, we have testamentary freedom in Ontario. And testamentary freedom means that you can do whatever you want with your money after you pass away. Other jurisdictions in Europe, you have a fixed distribution. And the amazing part of Islamic law is it's a hybrid of both. You have testamentary freedom up to 1/3, a discretionary bequest with some conditions. But the other 2/3 is fixed. And this actually reduces disputes, and it also leads to greater equity and justice. Now, in Ontario, and inshallah we'll see that, In Ontario, there are two exceptions to absolute testamentary freedom. So about 30 years ago, laws were passed in Ontario to ensure that a spouse, and that means a legally married spouse, can opt to take up to 50% of the estate if he or she wants to. They don't have to, but they have that right. Once again, they have to be a legally married spouse. In addition, certain beneficiaries or certain family members can make a dependent support claim. Let's say you didn't give anything to your children and you were supporting them while you were alive. They can go to court and, up to a judge's discretion, receive something from the estate. But the spouse, the 50% claim of the spouse is automatic if he or she applies for it. What happens in those cases is they are removed from the will. So let's say you gave them a smaller share in the will. They're removed from the will, including as executor or even whatever share, and they just receive their 50%. Now, I'm just doing broad strokes. Later on, hopefully, if we have time, we'll do questions, and you can always reach me later, inshallah. As I mentioned, probate tax, the official name in Ontario is estate administration tax. This is a wealth transfer tax. There's no national estate taxes in Canada as there are in the US and the UK. We do have unofficial estate taxes on death, which are capital gains tax, deemed distribution, deemed disposition of assets on death. So those are de facto capital gains tax, but there's no national estate taxes in Canada, so we don't have to worry about that. That's not necessarily a good thing. The billionaires got rid of that, but it is what it is. Instead, we have provincial estate taxes, which are more wealth transfer taxes, and they're unofficially known as their former name of probate tax. So when I refer to probate tax, it'll be that tax. Now, the rate of the tax was recently simplified, so it's now 1.5% of the balance of a deceased estate over $50,000. So let's say you passed away with an estate worth $550,000. The estate tax, first $50,000 is free, basically. For smaller estates, they get that break, and everybody does on the first $50,000. And then the remaining tax on the $500,000 at 1.5% would be $7,500. So it's not a huge tax. $15,000 on $1 million roughly, but you might as well avoid it if you can. So the first way to avoid it is to hold assets jointly. So your principal residence, yes, you will be taxed on your principal residence once both or all owners on the property pass away. So husband and wife are on the house. Husband passes away, wife gets the house, no tax. We're talking about probate tax, no estate administration tax. But when she passes away, there will be a tax of 1.5% on the net value of the house. So the valuation of the house minus the mortgage. Now that's the only asset where you get that break of a mortgage. The other key way to reduce estate taxes are for certain types of assets, which include usually private corporate shares. So let's say you have a private corporation or a private professional corporation, and you have shares, and those shares are owned by you and family members, perhaps. Now, we basically do take advantage of loopholes in the law that allow us to structure how you dispose of those assets. So what we basically do is we put your private corporate shares in one will, and that's called the non-probate will. And we put everything else in the main will. And there's a bit more detail here. So the primary, it's also called primary will and secondary will. So, but basically what we do is we avoid the probate tax of 1.5% on those assets that are segregated in the non-probate will. So let's say your professional corporation shares are worth $1 million. If we structure it in this way, you can completely avoid paying the $15,000 on the $1 million in share value of your professional corporation. And you can have third wills and fourth wills for artwork and so forth. Now, how do you decide why are we able to do this? There's a basically, the government the government of Ontario, these are provincial taxes. The government of Ontario gets its tax when you need to go and certify your will. Now, you need to certify your will because third parties like banks, portfolio managers need to transfer those assets to the beneficiaries, and they will only transfer the assets when they get the certificate from the government that this is the approved executor, and he or she is now responsible. We're off the hook. So once the institution gets that certificate, they follow the instructions of the executor. Now, if we can keep, however, so for bank accounts, houses, all the institutions or government departments will need that certificate. But if you have private corporate shares owned by family members, you may be able to get the beneficiaries who are family members or business partners to agree to waive that certificate and then just pass the shares without the certificate from the government. And basically the government has no opportunity to get its tax. So this kind of approach was tried about 20 years ago in Ontario, and the government tried to fight it. They lost in court. So now it's basically standard for significant estates where it's worth the hassle of doing these wills, the secondary wills, the legal fees, the management issue later. To the cost of that is offset by the tax. So kind of a rule of thumb, if you have assets in a corporation about $500,000 or more, then we probably should do this. Another type of trust is a Henson trust, named after a case, and it's basically a fully discretionary trust. As I mentioned earlier, this is for disabled beneficiaries who are receiving ODSP benefits. There's a low threshold that if they receive assets in their name, they'll lose their benefits, a monthly, modest monthly payment, but it also includes drug benefits. So we don't want the beneficiary who's disabled to lose lose the benefits from the government. So we basically put the asset into not a normal testamentary trust where the children will eventually have control of it and have right of recourse to benefit from those assets if the executor or the trustee is not doing their job. In this trust, they have no recourse. So it's kind of a double-edged sword. You put the inheritance of the disabled child or adult actually into this, but they will lose to preserve their benefits, but they lose control. So you really have to have a trusted executor. But it's the only way to do this. Another type of trust is insurance trust. And this is if you have a large insurance policy. So you have $1 million or $10 million in an insurance policy, as some of my clients do. We don't want the minor or young adult, leave aside the minor, we don't want the young adult beneficiary to get a $5 million insurance policy in their control. So once again, we do an insurance trust. This is outside of the will, so we avoid probate tax. There's a whole bunch of issues one has to be careful. Now, I'm not going to get into too much of the estate tax. I'll just keep an eye on the time too. But basically, even if you're a Canadian, so U.S. citizens will be subject to U.S. estate tax if they have assets more than about $12 million. It's indexed for inflation in the U.S. And the Republicans and Democrats have been fighting about this for decades. So the Republicans have been winning this, and so it's quite a high exemption. Now, so that's American citizen. So if you're an American citizen, and you may also be, so if you know you're an American citizen, pay attention, of course. You may not know you're an American citizen because you may have inherited your U.S. citizenship through one parent and never got a U.S. passport. But for U.S. tax purposes, you're a U.S. citizen, and the IRS is very aggressive compared to CRA. And they're all aggressive, but IRS is notoriously aggressive, and they will come after for their taxes. Now, if you are a Canadian citizen Now, basically, why there's these weird provisions, the tax is significant over $12 million. It's 18 to 40%. Remember, the Ontario tax is only 1.5% because that's a wealth transfer administrative tax. This is a real wealth tax. It's an increasing rate, 18 to 40%. This creates a more equitable society is the public policy benefit of this. But I just wanted to go into, for Canadians under a tax treaty, we can take advantage of a certain percentage of the $12 million or so in exemption, and it's based on the ratio of your US assets compared to your worldwide assets. So generally, we can get out of most estate tax, but here and we won't get into the details, we can talk about it later. I'm not a US tax lawyer, I should also add. So I can just generally tip you off when we need to get US tax advice. But basically, if you're a Canadian citizen and you have a US assets, like a US, a house and condo in Florida, certain US securities, and you're starting to reach a significant threshold, even with the ratio, even taking account the ratio of exemption, then we should start being careful about US tax issues. There's other tax things that we can do. So I focus on testamentary trust, which is on death. There's also inter vivos trust, which means during while you're alive, basically. I'm not going to get into this too much, but if you have significant assets and you're over the age of 65, or at least you, if one of you or your spouse is over the age of 65, you can transfer assets in something called an alter ego or joint spousal trust. So we work with accountants to set this up for you. And it's basically, there's certain advantages of doing it, but normally it's not worth the hassle and the accounting fees and so forth, unless once again, you're having a significant estate. Just to flag that for you. Similar, there's things like estate freezes where we want to, for an operating business, and we want to reduce issues related to capital gains. We can freeze the values of shares of the growth and kind of minimize future growth and minimize tax impact on beneficiaries, basically. So it all depends on. That's why I just want to point out quickly, when people think you can do a generic will, it's just madness. It's like trying to do your own dentistry, doing your own dental surgery, or not going to an orthodontist and just using things that will fix your teeth that you see on TV. If you're really lucky and you have a minimal situation, you may be able to get away with that. But remember, provincial law, each law is different. So there's no national will for Canada. If there's provincial, each province is different. So basically the rule of thumb, I would say, is, if you have assets more than 50,000 and or you have minor children or young adult children, you should get a will, basically. So formally, I should say everybody should get a will, but practically speaking, if you have nothing and no kids, you probably don't need a will. But if you have assets, say more than 50,000 as a rule of thumb, and you have children, or you have other beneficiaries that you want to make sure that, like other minor beneficiaries, nieces and nephews, little siblings and so forth, you may want to stepchildren, whatever is the situation. So now something else I want to talk about, of course, then you should get a will. Powers of attorney. So consider, we've been talking about wills. Now I'm just talking about powers of attorney. So consider your life into two halves, before a death certificate and after a death certificate. After a death certificate, of course, that's when the will gets activated through the probate process, and you pay the taxes to the government, you get the certificate, as I mentioned. Before you pass away, powers of attorney can help you if you, God forbid, lose capacity to make decisions with respect to your financial affairs or to your health care. So there's two types of powers of attorney: continuing power of attorney for property and a power of attorney for personal care. Personal care relates to healthcare decisions you know, what happens if you're still alive but you need ongoing care, or when to unplug the machine, God forbid. The other is continuing power for property, which is how do you manage all your property? So your bank accounts, your house, if you lost capacity, God forbid, like you're in a coma, or you just got dementia, or some other accident. Now, the key, a critical reason to have the continuing power of attorney for property is if you have a matrimonial home with your spouse. Matrimonial home means any property you acquired while you were married, and it may or may not be in title of both spouses, but generally stuff you own while you're married. You could say houses you own while you're married. You need a continuing power of attorney of property, because you can't, if you lost capacity and your spouse needs to sell to downsize, he or she won't be able to get spousal consent, which is required for a matrimonial property, because you're incapacitated. And then you need to go and get a guardian for incapable adult appointed, which is a court process and tens of thousands of dollars possibly. So it's much better to pre-give this consent through the continuing power of attorney for property. Now remember, a power of attorney for property without the continuing language is just one you might have done for a real estate transaction. That loses effectiveness if you lost capacity. So it has to be a continuing power of attorney for property. Just something very quick. Are funeral instructions effective? It's good to have them, but they're not binding. It's important how you choose the executor. Now, we'll go the last portion of our presentation is Islamic will. So how are we doing this in Ontario? And we have, you know, Ontario law governing us, and then we want to do an Islamic will. So just to clarify a common misconception, there's not two wills. There's not an Ontario will and an Islamic will. There's only an Ontario will, because we're bound by Ontario law, of course, as we should be. However, because we have testamentary freedom, as I mentioned earlier, for the most part, we can distribute our assets Islamically, or as Islamically as possible, or as Islamically as equitable in our situation, because of the testamentary freedom of Ontario. So remember, as I mentioned earlier, it's a mixed distribution. You can give up to 1/3 to whomever you will, who are not already receiving an assigned or Quranic share. We'll talk about that, inshallah. I just want to back up. We know a lot of people know some basic, you know, things about Islamic wills, that, you know, the male shares twice the share of the female share, and that's true within the same category and class, which I mean that a son gets twice as much as a daughter, a brother gets twice as much as a sister, but you can't compare a daughter with a spouse, with a wife, or a mother, and so forth. So you have to stay within the category. Now, in a modern context, when we'll talk about the equity issues of or the potential equity issues of this, but just want to remind people that in a historic context, Islamic law was probably the first legal system that gave fully vested shares to women. And that means that they actually had full and absolute control of their inheritance. It wasn't supposed to be controlled by a male relative. It was actually supposed, as long as they're adults, it was supposed to be their full ownership, absolute control. And during Islamic history, many women, they were in business and also inherited, and they set up, you know, great endowments and waqfs that you can read about now, funded scholars and so forth. So women were able to traditionally control their own wealth. And these are haqq Allah, which means that no one can take away your daughter's inheritance. No one can take away your wife's inheritance. No one can take away your mother's inheritance. And this was new to the Quraysh. And so the female inheritance was imposed on the existing Qurayshi distribution. So just a great quote, and this was my experience also. When I first started studying Islamic inheritance law about 12 years ago, it was a very strange thing. It reminded me of the hadith that, you know, Islam will return as a stranger. So welcome, give glad tidings to the stranger. It was a very strange thing. Like, why do you have all these elaborate rules and contingent beneficiaries, and some beneficiaries get blocked by other beneficiaries? But but as you get into it, you're just amazed by its cleverness and its equity, and its ability to distribute wealth widely and to avoid conflict or reduce the possibility of conflict. And so this prof from 100 years ago or more said the Mohammedan law of inheritance comprises beyond question the most refined and elaborate system of rules for the devolution of property that is known to the civilized world. And that's exactly how I feel once I got into it more. So as I mentioned, can we do an Islamic will in Ontario? We're not defining what an Islamic will is yet, but say a will that is inspired by our tradition, and generally yes. As I mentioned, there is the limitation on testamentary freedom, and a spouse, let me restate that because it's important. A spouse within 6 months can do an election, which means basically fill in a form with the government of Ontario and take half of the estate. And basically there's no way that you can stop it unless you did a prenuptial agreement or some other domestic contract to avoid that. But those are complicated and they can be challenged and set aside also. So it's much better to get this buy-in from the spouse if you're, depending on what you're doing. Now, I talked about some of the tensions in terms of the equity, and some of these issues are to deal with the tax issues, because our society our Canadian society is based on the husband-wife unit. We're based on the nuclear family. And so this makes sense. This makes sense in our reality. We're not a traditional clan-based society or really an extended family based society anymore. So we're husband-wife unit. So all the tax provisions are generally written for husband-wife relationships. So you get a spousal rollover for the RSP. Both spouses get a capital gains exemption on your principal residence. So if you start giving Islamic distribution strictly of 1/8 or 1/4 to the wife and 1/2 or 1/4 to the husband, you're going to have a mess with respect to principal residence. RSP, you're going to be like lose potentially 40% of it from tax right off the top, because the government is getting its money from the RSP one way or the other, because it's only a temporary reprieve from the government. And so you're gonna like deprive your beneficiaries. So one scholar said we shouldn't leave money on the table for the taxman to take unnecessarily. So once again, if you're doing a template where you're just dividing up the shares Islamically strictly with no regard to your actual holdings, you're just going to do injustice, and all the hard work that you did is going to be gone. So people say, oh, I'll just do an Islamic will, I'll write it, say Islamically, or I'll just write the shares out. It's way more complicated than that. If it were that simple, I would have left this area of practice 12 years ago because it'd be too boring. But it's fascinating because of how he deals with this tension and this equity. Now, how do we mitigate it? I'm not getting into the details of Islamic law. I'm not an Islamic scholar. I'm a practitioner of Islamic inheritance law, and we consult the scholars. But the basic cases are straightforward. But I'm not, the basic cases mean if you have a son for Sunnis, and if for Shia, if you have a son or daughter, those cases are basically straightforward. But what I want to talk about is how we reconcile and what are our mitigation strategies. And the key thing is, how do we stay true to the Islamic tradition with these mitigation strategies? Because we could just ignore Islamic tradition, and you have that right in Ontario, of course. But most of us don't want to do that. So the challenge is do an equitable distribution within the context, or within the informed by the tradition, basically. So how can we do that? You have a 1/3 discretionary share. So let's say you have an adopted child who doesn't inherit directly as a biologic child. He or she can get up to 1/3 of the asset of the estate through the discretionary portion. Or certain grandchildren who don't inherit can get it through that. A male inheritor can waive his extra share or and balance it out if he wants to. You can hold assets jointly with your spouse while you're alive, and you you do a pre-gift basically. So let's say the husband is working outside the home, the wife is taking care of the family at home and doesn't have an income. Say that's a common case. The husband formally is earning the money. So in classic Islamic law, it's his asset when he passes away. And the wife, he has children, they have children, the wife will only get 1/8. So that, is, you don't want your widow to be destitute or have a very minimal estate. So a husband can give his wife, while he's alive and healthy, whether we do it formally or informally, depends on the situation, a gift. You have to do it before you're in a state of marid al-maut, which means death, sickness. So we translate that as, say, terminally ill or critically ill. So you do that before. And then that way you've pre-gifted, say, half of your house to your spouse, and for example, and so if you pass away, she already owns a half, and then she gets the extra 1/8 from your share. So there's ways to do this, and it depends on the assets. We have to look carefully at the assets and decide how to do it. For assets with beneficiary designations, we may want to set up the beneficiary designation. You can also equalize your daughters by if you have insurance through work or you've decided to get an insurance policy. I'm not saying you should do that, but if you have it, you can give more shares, more of the plan of the proceeds to your daughters versus your sons to equalize that, because those are kind of formally outside the Islamic distribution. I'll try to wrap. Yeah, we're almost wrapping up, and then I'll kind of go back to a couple of things. I just want to make sure that everybody remembers, if you want to, you can give sadaqah through your will. Now, it's better Islamically to give sadaqah when you're alive, and especially when you're under challenged financially, even to give a little bit, because there's more reward in that. But of course, it's great to do sadaqah on death, and that's how many of the endowments that I mentioned earlier were funded through wills. And today, a lot of endowments are funded through wills in Canada. Now, remember, you're limited by the 1/3 discretion. There's also hadith saying that it's better to spend on your family, and it's foolish to leave your family destitute on your death and give all your money away. There's specific hadiths relating the conversation between Rasulullah SAW and a Sahaba about that. In Canada, federally, you can get a tax credit for 100% of your income in your terminal return, your last tax return that the executor has to file. So basically, you can avoid all the income tax of your last year of life through giving money to a charitable registered charity. So I'll just talk about the process, but people might have interest on just Islamic inheritance generally. So I just want to summarize very quickly. The mandatory heirs in Islamic law are spouse, parents, and children. So your father, your mother, your husband or your wife, and your sons and your daughters. All of those are mandatory heirs. Let's say you're a convert and some of your family is not Muslim. You can give from that 1/3 discretionary share to your non-Muslim parents, for example. So you can actually give greater than they might inherit Islamically. It's capped by the 1/3, so it depends on how many people you have to do that to. But there's great flexibility. There's and you can do inter vivos gifts while you're alive too. So the mandatory heirs are spouse, parents, and children. If you have a son, your siblings are cut off. That means they don't inherit. So if you have a son, your brothers and sisters don't inherit. For Sunnis, if you don't have a son, your brothers inherit, and brothers and sisters inherit, but it's a small share. And I'd like to close with, if I can state it properly, let's say there's a case where a woman passes away, Islamic case, and she leaves a husband, a father, and a daughter. So a woman dies, she leaves her husband, her father, and her one daughter. So who gets the biggest share? Remember, this is 1400 years ago, and it was quite amazing. So how you do it is you give the husband his fixed share. Because there's children, he gets a 1/4. You give the sole surviving daughter her fixed share, which is a 1/2. So she gets a 1/2, and the father gets what's left over, which in this case is a 1/4. So basically, the husband gets a 1/2. The husband gets a 1/4. in this example, the father gets a quarter, and the daughter gets the single biggest share, which is a half. So this 1400 years ago, the daughter got a bigger share than the husband and the father in Qurayshi Arabia, and there was nothing anybody could do about that if you believed in this system. So there's a lot of kind of false assumptions of equity issues. Not to underestimate that there are real equity issues. To just do a formal Islamic distribution with no thought and no consideration of what's actually going on in the family. But the remedy is to do this within Islamic spirit, basically, and use provisions within Islamic law, inter vivos gifting, the 1/3 discretionary portion, I missed a slide earlier where a scholar came up with an innovative way of you could set like a debt to your wife. Like say sorry, I'm doing kind of sexist examples, but they're the usual scenario or the common scenario. Say the wife was working at home for many years. You can say that she had unpaid labor of $30,000 a year for 20 years. So she's owed $600,000 on your death. Now, as long as you're trying to do this, not to do injustice, the scholar says, to the other beneficiaries, you're trying to create an overall equity. So there's creative things that we can do, and alhamdulillah, over the last 12 years have figured out in part how to do this by God's grace, inshallah. And may Allah guide us that we're not misleading and misguiding people. I just want to move forward on the process. We complete a questionnaire so that I send that to you. We select guardians and executors. We consider tax and trust issues. We draft, review, and then we execute. And just as an update, because of COVID, in April, the government of Ontario changed the rules, so now we can do the entire process remotely. Before, we always had to at least meet in person to sign the documents because you need 2 witnesses to execute a will, to sign a will, to make it valid in Ontario and most jurisdictions. But now we can do the whole process remotely. It's not through DocuSign. You have to do a live viewing of that. So please feel free to contact me through Nadeem. Or you can email me directly. My website is Danial Law with an A, DanialLaw.com, and you can email me, text me, or I'm on WhatsApp a lot. So WhatsApp me anytime. I'll be happy to respond to questions. Thank you so much, Nadeem, again, for giving me this time, and thank you everybody for listening.
Jazakallah khair, Brother Ibrahim. So we're going to get started on some of the questions that have been coming through. And I'll start with this one here. What if I have estates in Alberta and Ontario? Alberta has no probate taxes. I move to Ontario. Will I have to redo my will? And can my investment accounts remain in Alberta if I move to Ontario?
So great question. Thanks for raising that. So the basic rule is you should have a will for every let me say not have to. You should check if you need a will in any jurisdiction that you own assets, especially real property, so real estate, or you're resident in that jurisdiction. So if you live in Ontario and you have a house in Alberta, leave aside the probate issues for now. You may need to get a will in that jurisdiction of Alberta for the asset there. Now, you may not need to because of what you said of the probate tax in Alberta is minimal. So you may not need it. So probably not is the short answer to your question. I'm not giving you specific legal advice, but just generally speaking, you may, in your scenario, you may not. But further, more generally, why do you need a will in each jurisdiction? Because the probate tax is totally different. Like Alberta, you don't need to do probate tax planning for the most part. Ontario, you do. US and UK, you need to do major real estate tax planning. Now, with respect to the investment, you may or may not need to transfer. It depends. I would leave that more to your investment advisor. And with respect to estate law, depending once again on what I said about the tax regime and those in that jurisdiction, you may either move it to avoid taxes, or you may at least need to have a will.
Yeah,
This
and
also applies to overseas wills. Also, if you have assets in Pakistan or India or Egypt, you may need to get a will in those countries. And what we do is we limit the Canadian will to Canadian assets, and we have to be careful not to revoke the will in the other jurisdiction. But you should always check with a lawyer in that jurisdiction, whether it's a province, state, or country.
yeah, and if I could just shed some light on the investment account topic, you know, we're legally, investments don't, unlike real estate, it's not a physical asset that's in a location. As professionals, we are liable to find out where does the client officially reside, where is the official resident of the client. And so that really kind of just determines the domicile of the investment account, not so much, you know, unlike real estate, of course.
Right.
So just a quick question here. Are private shares the same as shares in companies or RSPs that have beneficiaries already named?
Okay, so private corporate shares refer to your private corporation that you started yourself, say, that's not publicly traded. So let's say you have a professional corporation because you're a doctor or another professional, or you have a business and you started a General Ontario corporation, and that's owned, those shares in that company are owned by you or your spouse or your family members or your business partner and so forth. So that's what I mean by a private corporate share. If you have a share portfolio with SHariaPortfolio or whomever, and it's shares, and I'll let Nadeem talk more also. Let's say that's in your RSP or your TFSA, and you have a whole bunch of companies with Sharia filter and so forth. And those are publicly traded companies, and it's a registered plan like an RSP or TFSA, and you've named the beneficiary. That's something totally different. We can't avoid probate tax on those, because in order for the institution to pass those assets, they're going to require that certificate from the government that I pointed out earlier, and you'll have to pay the tax on that. If I'm understanding the question correctly, that's those are two different things. The probate planning is to avoid the 1.5% tax on private shares in your private corporation. Nadeem, maybe go ahead.
Yeah. No, I think you just answered that question pretty much. And so there's another one here. In case one of the parents, either father or mother, passes away, what happens to the matrimonial home in the absence of a will?
Okay, so great question. So this varies province by province. So if you don't have a will, you're governed by the intestacy laws. Intestacy means you didn't have a testament, you didn't have a will, and you're governed by the laws of that province or state. So in Ontario, the first 200, so I'm assuming that the house wasn't jointly owned. So let me do that example first. If the house is jointly owned and it's joint tenancy, which is a certain way that most spouses own their property, if the husband passes away and both husband and wife are on the property, the wife is also named on the property, she will get the whole house if the husband passed away, and vice versa. So what I recommend to defer the probate tax and to make sure there's equity for the widow or widower, you should make your house joint. Now, in the scenario where in that way the spouse is protected, he or she gets the whole asset. Same with bank accounts on death, joint bank accounts. Now, if the house is only in one person's name, say the husband owns the house, he passes away, and the wife's not on the house. So then you go to, and say there's wife and children. You go to the default bill in Ontario, which is in the statute, and it basically gives something called a preferential share to the spouse. So in Ontario, that is right now 200,000. So the first 200,000 will go to the husband or wife. The the remainder over 200,000 will be divided among children and spouse. So the spouse will get another part of it, But if you have more than, and if it's one child, it's 50-50 between the spouse and the one child. If you have more than one child, it'll be 2/3 to the children and 1/3 to the spouse. So basically, the bigger the estate, like I know somebody who passed away without a will, he never went to a lawyer and so forth, and he had a big estate. His children, even though they were minor, they got the bulk of the estate because the wife got the first 200,000, and then only 1/3 of over 200,000. The kids got millions of dollars. So did the wife, but the kids got majority because they got the 2/3. In Alberta, that preferential share that I mentioned is only 50,000. I'm not an Alberta lawyer, but from what I last remember of Alberta, it was 50,000. So basically, you're going to have a big mess if there's no will, because the minor children might inherit. The Office of Public Guardian and Trustee gets involved in Ontario to supervise it. An executor has to be named because the mother's not or father's not automatically the financial guardian of the children. Only the physical guardian is not necessarily the executor. So you get a mess. So basically, try to avoid that. Do a joint in the meantime until you do a will.
All right. Okay, I got another question here, and I get a lot of this as well. If you own U.S. stocks through a Canadian brokerage, do you have to pay U.S. estate tax, or just Canadian, or both?
So these are all facts specific. I don't. U.S. estate tax. If you're a Canadian citizen or resident, you get to take advantage of a portion of that $12 million or so exemption on U.S. estate taxes. So, and the ratio is of your U.S. situs assets versus your worldwide assets. So basically, you may get a portion of you if you may or you will get a certain amount of exemption, but there's no way to give you an answer until you look at the numbers. But you should talk to a U.S. accountant or a Canadian accountant who knows U.S. tax law. Nadeem, why don't you go ahead?
I know that the first 60,000
Yes.
is exempt. With Canada and U.S., there are some tax treaties
Exactly.
in place.
Right. No, you got the basics. There's a small exemption of the 60,000, which is so out of date. But yeah, what Nadeem said is correct. And I think we're both saying is it's fact specific and it depends. Sorry, the lawyer classically says it depends, but it actually does depend.
All right. So I got another question here. I guess this would be towards the Islamic will portion. What if there were parents and siblings only, no kids?
Okay, so remember, mandatory heirs are spouse, parents, children. So there's no kids, so they just get removed. So sorry, Nadeem, the example was parents and siblings. So let's say there's no spouse, there's only parents and siblings. So if you have a father who survives you, the father cuts off the brother and sister. Because as I mentioned, Islamic law came basically, it didn't disrupt everything the Quraysh were doing. It continued whatever was, the Prophet continued whatever the Quraysh were doing that was not unjust or inequitable or some other reason that only Allah knows why it was prohibited going forward. So the basic pre-Islam, pre-Quranic, let me say, pre-Quranic revelation was that the son got most of everything. So what is Sharia overlaid on that was that no, daughters get stuff, parents get stuff, maybe fathers used to get stuff, and siblings get stuff, and so forth. So basically, the general rule was, and it still is, find the closest male relative. But what Islamic law added to that was, before you find the closest male relative and give what's left over, you have to give these shares to other people, which include the mother, possibly the siblings, including sisters, and daughters. And there's certain beneficiaries, like a daughter can get a fixed share if there's no son, or can get half of the son's share and become a different type of heir. In that example, if you have a father and a mother alive, your siblings do not inherit because your father cuts off your siblings. But if your father passed away and you have a mother and brother and sister, then your mother gets a certain amount and your brothers and sisters get what's left over. If you don't have a brother, you only have a mother and a sister, your mother gets a certain amount, your sister gets a big amount, but it's still a certain amount. And then we look for your father's brothers to get the little bit left over, because it's following the old hadith of Rasulullah and the pre-Islamic thing of follow the closest, give what's left over to the closest male relative by blood.
Okay, just a few more here. Can we make a will for assets outside Canada for our kids and wife living in Canada?
Yes, so basically, I did mention that you should have a will wherever you have assets, but if you just have one will, it may be okay. Like you might just have a will for Canada and you have a Florida condo and not have a will in Florida. I don't recommend that. You should talk to a Florida lawyer and see what the benefits are of having a will in that jurisdiction. But yes, if the question is if you can have assets outside of Canada, overseas, or the US, and just have a Canadian will or Ontario will, you can do that. But we have to go through the assets and decide what's the best to do. And remember, let's say you have assets in an Islamic mandatory distribution and you didn't do your will Islamically, that will may be ignored in that jurisdiction, and not even Islamic jurisdiction. Say in a European jurisdiction, it may or may not be recognized. I'll just give you a quick example. In India, you can, by default, if you're Muslim, you have Muslim personal law. Hindu, you have Hindu personal law. You can opt out of that in that country with a will. So it all depends, basically.
Okay, and a few attendees asked the same question pretty much. What's the average cost, for setting up a will?
Sure. No, thank you for that question. So the basic will, and that's probably 90% of people's wills, starts at $395 for the first will, and then it's $195 for the spouse's will, and then powers of attorney are about $95. Now that is 90% of wills. So I do flat fees most of the time, and we decide that before we go forward. So I say, this is, once I know your basic thing, this is what it is. You want to proceed, and then we proceed. Now that doesn't include if we do an insurance trust or a Henson trust or the probate planning. So those are relatively rare for most people, but then those are a different set of flat fees, basically. So for the probate planning will, that'll be for the private corporate shares, but that might be a couple thousand. And don't do it unless your corporate shares are worth $500,000 or say, where you saved $7,500. So you pay a couple thousand legal fees, you're still saving $5,000, say roughly. So I always say don't pay for professional fees until you actually need it, because maybe you won't need it. But when you need it, you should do it. So, and these are rule of thumbs, basically. But the basic will, $395 for the first one, $195 for the spouse's one, if they're mirror image, so if they're similar.
Okay, and brother, your services are in Ontario or any other province?
Okay, great question. So no, I'm only licensed in Ontario. Several people recently have been asking me to get licensed in Alberta and BC and Saskatchewan. So I may do that. Now with remote signing, depending on their jurisdictions, but a lot of them changed it. We may be doing that by next year to be able to assist people in BC, Alberta, and Saskatchewan. Quebec is a totally different legal system. So if you live across the border in Ottawa, but you're in Gatineau side, it's a totally different legal system. So we won't be able to help you there. Now, informally, we can do consulting. Like I also can do consulting on Islamic distribution. So I wouldn't be your lawyer in Alberta, BC, or Saskatchewan, but I can be your Islamic law consultant for inheritance law.
And do you have to do a will with a lawyer, or can it be done?
No, you don't have to. So if you're like, you're not married, you don't have kids, you don't own a house, you don't have many assets, you probably could either not have a will, even though I'm not supposed to say that, other lawyers will get mad at me, or you can maybe do your own will. But so I would say that, it's like, once again, doing your own dental work. If it's just like flossing, go ahead. But if you're going to take out a tooth, I wouldn't do that. So it depends.
And I think we'll end this webinar with this last question here, and it's also investment related. If the beneficiary on the RSP is spouse to minimize tax implications, should it be distributed Islamically after death? Would this be a separate document so that the RSP distributed Islamically?
Okay, great question. So this is kind of what we focus on. Now, you do not want a separate document in writing because it could negate your will. Because let's say, oh, I'm doing this will, I'm giving everything to my spouse, or I have a beneficiary designation. And then you write up another document that could be interpreted as a modified beneficiary, as amended beneficiary designation, or an amended will. Then you've just reversed everything that you wanted to do for the tax purposes. So what you basically, so be very careful about writing anything, especially after you do the beneficiary designation with your investment advisor, or you did it after you did the will with your lawyer. Be very careful what you write down. To solve what you're talking about it is, Islamically, we're responsible as an imam said in Toronto, in Oakville, actions are by intention, as we know in the famous hadith. So if you do your best to intend to do an Islamic distribution, and then you trust your spouse to distribute it, and then they don't do it Islamically, as he said, it's on his or her head. You did your part, basically. And maybe something came up and she was destitute and needed to do that. Allah's forgiving too. So it all depends on the situation. Get the buy-in from your spouse. Do your wills together. The husband and wife do the wills together. Get the buy-in from your adult children that maybe don't take your share until your mother passes away also, and your father passes away also. The beneficiaries can agree to defer their distribution. So, have mercy when you're doing all this. I have a case where a client, elderly widow, her son was like demanding the money right there and threatening not to spend time with her and so forth. It was horrific. So we tried to mediate that case. So try not to do that, basically. And these are Muslim, so it's unfortunate.
No, wow. Again, Jazakallah khair, Brother Ibrahim, for your time and your words of wisdom. And, I hope everyone definitely learned a lot. Again, if you need to get in touch with Ibrahim, you can reach out to either myself or him directly. For SHariaPortfolio, my information is right here. If anybody out there is looking for any type of financial planning, investment services, retirement planning, please, do not hesitate to reach out to us, inshallah. Again, thanks again, everyone, for joining us. We are kind of a little bit over time, and I apologize if I couldn't get to all the questions. We did have a lot of questions, and for the sake of time, and I think we are in Maghrib territory here. So inshallah, maybe I'll save some of these questions and I'll forward them over to you, brother. All right.
Thank you so much, Nadeem, again for inviting me, and it's great you guys are in Canada. Your services. Thank you so much again.
Jazakallah khair. Assalamu alaikum.
Assalamu alaikum.